In these tough economic times, it's not surprising that a lot of folks are looking for ways to avoid paying their debts. One common approach is to transfer assets from the person who owes the debt to someone else. It's called fraudulent transfer, and it happens a lot. David Wall is a director at EP Forensic Services in California and is an expert in uncovering fraud in commercial litigation cases. David, thanks for joining us.
Thank you for having me, Oliver.
Fraudulent transfer has been around for a long time, and given the recent economic conditions, has anything changed in the way debtors are trying to avoid paying their debts, and has anything in the law changed to affect that as well?
Well, debtors are becoming much more desperate and much more aggressive, so we do see these types of, affirmative actions taking place for people to protect their assets. We also see a proliferation of firms. Typically, these are like paralegal type offices that really facilitate and help debtors to engage in asset protection schemes. The other major challenges and changes that we've seen over the course of the past, say, 10 years or so, particularly in California. Now, I practice in California. What happens in California, I think, is happening across the United States, and I think the problems and things that we face here are typical of experiences elsewhere. And the major changes really are these. The courts are massively overloaded. The time to get a case to trial in civil court has expanded tremendously over the last few years. Attorneys and administrators and judges are predicting that it will be 5 years to bring a case to trial.
Wow.
So under these sorts of circumstances, the challenges become insurmountable. The challenges in many cases, particularly when we're talking about commercial litigation that's often in the range of the low to mid six figures, you just can't do it. And that's the most disturbing thing about recent developments is that, creditors, people that work in creditors' rights are just taking the option of writing off their losses rather than engaging in litigation where they're, in essence, throwing good money after bad. Because I believe that pattern seriously undermines the credibility and the effectiveness of the court system, and that's to the detriment of our economy in the long run.
You mentioned that some of the debt assistance programs and some of the counselors that are out there have been using this fraudulent transfer scheme in a much more aggressive way. Is that making it more difficult for attorneys and investigators like yourself to figure out what's really going on in these transfers?
Yes, because people are, getting more savvy about it. There are not just these small shops that do asset protection and paralegals, but there are attorneys and accountants that really specialize in helping the debtor, play in the gray zone and defeat the rightful claims of legitimate creditors, of legitimate claimants. And recent changes in that area include a lot of new privacy protections that are afforded to litigants. Mm-hmm. So in California, for instance, the ability to discover a lot of this financial information has been greatly impacted by new notice requirements for consumer protection and privacy protection, and a greatly facilitated and a much easier process for consumers to raise objections and interfere with the ability of attorneys to compile the information that they need to prove these claims. And moreover, not just the state legislation, there was, going back a ways, there was the Graham-Leach-Bailey, which severely impacted usual and customary procedures in commercial litigation to obtain financial records and financial information. It's made it more cumbersome, more expensive, more time-consuming, and all of those challenges tend to increase the cost of litigation, prolong the litigation, and work against the interests of creditors and claimants. That's unfortunate.
A lot of folks would look at situations like this and say, well, I really didn't mean to conceal this transfer. It was intended as a gift or some other excuse for why those assets are no longer in their possession. Is intent a driving factor in these kinds of situations?
No. Intent is not necessary, and come see my seminar to learn about that. You do not have to demonstrate intent to prove that a transfer was a fraudulent transfer. And I will show you at least 3 ways that a creditor's attorney can prove that a transfer was fraudulent without ever having to demonstrate what was in the parties' minds. And we get that a lot. Defense attorney, their first ploy is, I represent the daughter. She's good. Leave her alone. She didn't mean to hurt anybody. Baloney. Give it back. That's my client's money, and we want it back.
Well, that's a perfect segue to talking about your seminar. We appreciate you being here. Thank you for your time, and you can learn a lot more about fraudulent transfers from David at CLLA's fall meeting. That's November 10th through the 12th at the Sheraton New York Hotel, and we hope to see you there. Thanks again, David.
Can't wait.